What is the right to collective bargaining? When we hear the phrase collective bargaining, it can sound like legal jargon. But for millions of workers, it's one of the most powerful rights they have on the job. Collective bargaining means employees come together, usually through a union, to negotiate with their employer over wages, hours, benefits, and working conditions. The big question is, what exactly is the right to collective bargaining, and how far does it go? Can our employer refuse to meet? Are there limits on what can be negotiated? And what happens if either side breaks the rules? In this video, we'll break it all down. We'll explain what the National Labor Relations Act says, what topics are covered by collective bargaining, what employers are required and not required to do, and what real-world cases show us. By the end, we'll understand how collective bargaining works, why it matters, and how it protects workers' voices. 1. The Legal Foundation, Section 7 of the N.L.R.A. The National Labor Relations Act, N.L.R.A. of 1935 is the cornerstone of labor law in the United States. Section 7 of the Act guarantees that employees have the right to form, join, or assist labor organizations. Engage in collective bargaining through representatives of their own choosing. Engage in concerted activities for mutual aid or protection. This means that workers, once represented by a union or other chosen group, can negotiate with their employer as a group rather than as individuals. The law recognizes that bargaining collectively balances the power between employees and management. Example: imagine a group of factory workers negotiating for safer equipment. One worker alone might be ignored. But through collective bargaining, the employer must meet with the union and discuss safety improvements in good faith. So Part 1 shows us that collective bargaining is not just a concept, it's a legal right embedded in federal law. 2. What collective bargaining covers. Collective bargaining typically addresses three categories: mandatory subjects, permissive subjects, and illegal subjects. Mandatory subjects are issues that directly affect wages, hours, and working conditions. These include pay scales and raises, overtime rules, health insurance and benefits, scheduling and shift assignments, safety rules. Employers are required to bargain over mandatory subjects if requested. Permissive subjects are issues that parties may choose to negotiate but are not required to. Examples include internal union matters, management structure, or certain business decisions. Illegal subjects are off limits altogether, like agreements that discriminate based on race or gender. Example: a teachers' union negotiates class size limits. Because class size directly affects working conditions, it is a mandatory subject. If the school district refuses to discuss it, that can be an unfair labor practice. So, Part 2 clarifies, the right to collective bargaining has defined boundaries. Employers must engage on mandatory topics, may engage on permissive ones, and must avoid illegal proposals. 3. Good faith bargaining. What the law requires. Section 8 of the N.L.R.A. requires employers and unions to bargain in good faith. That means they must meet at reasonable times and intervals, exchange relevant information, make sincere efforts to reach agreement. However, the law does not require either side to agree to a proposal or to make concessions. It only requires genuine negotiation. What counts as bad faith bargaining? Refusing to meet at all, showing up but making no real effort to compromise, withholding important financial information. Surface bargaining, going through the motions without intent to reach agreement. Example: a manufacturing company meets with a union but refuses to share financial data needed to justify wage freezes. The N.L.R.B. may rule this as bargaining in bad faith. So Part 3 explains that the right to collective bargaining is more than symbolic. It obligates both sides to engage sincerely. 4. Strikes, lockouts, and enforcement. What happens when bargaining breaks down? Workers may strike, and employers may lock out employees. Both are legal tools under the N.L.R.A, but they come with conditions. Economic strikes, where workers strike over pay or benefits, are protected, but employers can hire permanent replacements. Unfair labor practice strikes, where workers strike in response to employer misconduct, give employees stronger rights to reinstatement. Employers, on the other hand, may use lockouts to pressure unions during negotiations, but lockouts must also comply with the law. The National Labor Relations Board, N.L.R.B, enforces the rules. If either side files charges, say for bad faith bargaining or retaliation, the N.L.R.B investigates and can order remedies, including reinstating workers, requiring further negotiations, or penalizing employers. Example: nurses at a hospital strike over unsafe staffing levels. If the hospital refuses to reinstate them after the strike ends, the N.L.R.B may intervene, especially if the strike addressed unfair labor practices. So Part 4 shows that bargaining is backed up by real enforcement mechanisms. 5. Real-world cases of collective bargaining. Case 1. Steelworkers in the 1950s. The Supreme Court ruled that management had to bargain over pensions, recognizing benefits as a mandatory subject. Case 2. Flight attendants. A union demanded new scheduling rules. The airline refused, claiming it was a management right. The N.L.R.B ruled scheduling is a mandatory bargaining subject. Case 3. Recent Starbucks cases. Workers in multiple stores unionized. The N.L.R.B found that Starbucks failed to bargain in good faith by delaying meetings. Orders were issued requiring bargaining sessions. Case 4. Teachers' strikes. In some states, bargaining impasses led to strikes that forced districts to negotiate class sizes and pay. These cases remind us that the right to bargain is real, and when employers ignore it, legal remedies exist. 6. Limits on the right. While the right to collective bargaining is strong, it is not unlimited. Supervisors and managers are excluded under the N.L.R.A. The law applies to most non-supervisory employees. Public employees often fall under state labor laws, not the N.L.R.A. Teachers, police, and government workers may have different rules. Certain industries like airlines and railroads are governed by the Railway Labor Act, with separate procedures. Illegal activity during bargaining, like threats or violence, removes N.L.R.A. protection. Example: public school teachers in some states cannot legally strike, even though they can bargain. Their rights depend on state statutes, not the N.L.R.A. So, Part 6 shows that while collective bargaining is broad, it has clear limits on who is covered and how it works. 7. Why collective bargaining matters. At its core, collective bargaining is about balance. Without it, workers negotiate as individuals against large corporations with far greater power. With it, they stand as equals at the table. Collective bargaining has led to historic gains: the 40-hour workweek, health insurance benefits, workplace safety improvements, and protections against discrimination. Even today, union contracts continue to raise standards not just for members but for entire industries. The bigger picture is this: the right to collective bargaining is not just a legal rule, it's the foundation of workplace democracy in America. So what is the right to collective bargaining? It's the legal right under the National Labor Relations Act for workers to join together, choose representatives, and negotiate with employers over wages, hours, and working conditions. Employers must bargain in good faith, and the N.L.R.B enforces these protections. While supervisors, managers, and some public employees fall outside the N.L.R.A, for millions of private sector workers, this right remains central. It empowers workers to speak with one voice, seek fair treatment, and hold employers accountable. If this video helped explain collective bargaining, share it with your coworkers. Knowledge of our rights is the first step toward using them, and collective bargaining is one of the most powerful rights we have.